Good afternoon. My name is Barton Morris. This is Nick Galendez. We are lawyers at the Cannabis Legal Group, and this is Cannabis Live. We do this every Friday at 2 p.m. now, and we're doing this from our offices here in Royal Oak. And today we have a show that we have been planning for a couple weeks, simply just to answer your questions. We have a lot of people calling our law firm asking questions, and we do our best to answer them. Whether that be with phone calls, or we get a lot of people on Facebook, emails, all types of different questions, which we, by the way, we do enjoy. It is important for us to know exactly what's important to our industry, to our clients, and so it helps us make sure that we're on top of everything that we're supposed to be on top of, and that includes not only just in Michigan, but nationally as well. We're very much interested in that because that's super important too. So. That's what we're going to do today, just go over some questions. If you have any questions, please send them to us online through this show. We have somebody that's going to provide us those questions, and so we'll answer them on air right now. If you do so later, if you're watching this show, you're not live, this is of course going to be on our YouTube channel, as all of our shows on our YouTube channel. By the way, I think this is episode 87 of Cannabis Live, so very cool to be getting to close to 100, which is actually kind of crazy. So if you have any questions, shoot them to us. If you're watching this not live, shoot them to us anyway, because we'll answer them for you, and if we'll get back to you, we'll put it on another show, whatever the case may be. One of our number one goals is to help the industry and be an asset to the industry, and so that's what we endeavor to do. That's what we do with this show, and that's what we're going to continue to do in the future. All right, so now I guess we're going to talk about current events and news that's happened recently within the last week.
Thank you, Barton. So today in the cannabis news in Michigan, kind of going to give you an update of what happened locally, as well as some interesting news happening at the federal level. One of the biggest topics, I think, from the very beginning of this whole process was caregiver product, temporary operations, and how to best kind of transition from the unlicensed gray market into the regulated licensed framework that the MMFLA set up. So with the change in administration and with different things falling into place, Lara did announce recently that they are going to recommend to the licensing board that they adopt this new resolution. There have been a lot of resolutions going around about caregivers, temporary operators, even licensed facilities having to take in caregiver product, different rules going on with different provisioning centers, with growers and processors, and the rules were frankly kind of changing and a moving target. What Lara is going to recommend to the board at the next meeting is that they extend the time for both licensed grow facilities and licensed process facilities to take in and source caregiver product as long as certain protocols are met, such as being tested. The thing that it does change, though, is that this completely prohibits temporary operating facilities from operating past March 31st, and also prohibits licensed provisioning centers from bringing in caregiver product past March 31st. So what happens next is at the next board meeting, I believe it's March 21st, the board will take up this resolution and decide whether or not to pass it. What this would do, though, is allow for caregiver sourcing by growers and processors until a later date that the department believes will be sufficient enough to have product in the system. Other than that, the excise tax for the MMFLA provisioning centers has been taken away as of March 6th. The sales tax is still in existence, but after March 6th, the actual 3% excise tax that was in the MMFLA said if the adult use law passes, there's a certain date by which the excise tax is no longer collected. I think that was another kind of major news as far as timeline-wise goes from Michigan. And then from a federal level, we had another kind of bipartisan legislation to end marijuana prohibition. It was introduced by two representatives. It's called the Ending Federal Marijuana Prohibition Act. haven't read the full law, but I believe that it is similar to the States Act and the Safe Banking Act, which would more or less open up the doors, deschedule marijuana as a controlled substance, allow the states to have their own say with whether or not they want to license and allow certain conduct. So we're continuing to see Michigan move and tweak and evolve its rules and its processes. We're also starting to continue to see more openness and more willingness for the elected officials at the federal level to kind of have meaningful legislation to hopefully end marijuana prohibition. With that, though, that's all the news. We're going to continue to keep you updated as the weeks go by. There's always a lot of news going on, so we will continue to keep up to date on that.
All right, well, that's quite fascinating. And I'll tell you one thing, I actually had a question for you. You said that this was a resolution that the Department of Licensing and Regulatory Affairs had put forth, and it's up to the board to vote on it on March 21st, right? So, first of all, I don't think a lot of people understand that it's really not final until that happens. Is that correct?
Right, yep.
And then the second question would be then, like, a lot of people don't think the board's even going to show up. You know what I mean? like they've been eliminated by the governor, right? They've got only 2 more months before April 30th, before the board's been eliminated. Some people are wondering, what if all the board members don't show up? I personally think that they're going to show up. They're going to execute their duty. They've been appointed to do something that they're going to finish the job. But what do you think?
Well, yeah, I mean, and just like in a lame duck session where legislators are on their way out, they still have to go to work. They still have to try to do their job and what they were put in those positions to do. So just like with the licensing board, Governor Whitmer issued that executive order. The legislature has 60 days by which to veto that or turn that down or challenge it. So for all intents and purposes, just like with this resolution, that executive order isn't final yet. So until, for example, the licensing board says, okay, this resolution is just a recommendation from the agency that's doing this for marijuana regulation, and it's not set in stone yet. Just like the executive order eliminating the board hasn't been set in stone yet. That would take place April 30th, 2019. So I anticipate they're going to still continue to do their job as they have been. They are appointed officials, and I think they're responsible adults and will be able to take their job seriously as they have been through this whole time period, and will continue to do what's right based on their position, based on the due diligence and the way that they believe that this should be voted for or voted against. So.
I agree, and I think it'll be certainly interesting to see how they behave and how they act upon certain applications, but I see no reason why they shouldn't continue to do the job that they were appointed to do. Hopefully they'll do so in a professional, rational, and responsible manner. There's a lot of people and a lot of money and licenses are on the line, so I'm sure that things will go well, is at least what we've been used to in the past. All right, so we're going to get to some questions and answers, and thank you again for submitting questions, and thank you for watching. I want to thank and welcome Mary Jo. She asked me a question earlier this week. I told her to tune in today, and she did, and so I want to welcome her and answer her question. At least at the time, it was about minimum capitalization requirements. And specifically, I think she wanted to know whether she could use some real estate perhaps that she owns or somebody else owns, a vacation home here in Michigan, to satisfy minimum capitalization requirements. Nick, what do you think about that?
That's a typical question that we get asked by everyone. It's it'll be a hypothetical. I own this property here, XYZ, can it work? Generally, yes. The law says you can use liquid, non-liquid assets in various amounts, and it has to be attested by a CPA. So the general question to that is yes. The more specific question, though, and what we try to do and what all the other attorneys and CPAs and consultants and everyone who are working on applications on behalf of applicants are doing is really specifically hammering down what assets you own, whether they're encumbered by any liens or mortgages, trying to really pinpoint what capitalization really needs to be put up front and what can and can't be used and what would be better and kind of more straightforward to use. And one thing that we've been seeing is that the minimum capitalization amount is the minimum amount that the state has determined people need to show in order to maintain and operate the facility. If you're thinking of a grow facility, that might make sense. if you're looking for a provisioning center in a very populated and a competitive area, you're going to need to show capital because it's a competitive application. So you're going to have to wow the municipality. You're going to have to do a lot of things above and beyond just showing that rental property and the minimum capitalization in order to apply. So just to circle back, generally it really is specific case-by-case basis, and none of the questions and answers we're really going back and forth with on this show or any show really should be rendered as legal advice. We're providing education and knowledge, but really as it pertains to each specific individual, it really is a case-by-case basis. So that would be a question that you would talk to with your CPA, with the attorney, or other consultant or person that you'd be having do your application specifically for that issue.
Can you comment on the necessity for the applicant to have the ability to satisfy that application requirement as opposed to the supplemental applicant? Mm-hmm. You understand what I'm saying?
Yeah, and I think what we've seen is that due to the banking situation, many bank accounts, companies can't go ahead and open up a bank account at one of the major banks. It's whether they do before the application process or not, sometime down the line that bank gets a little ping saying, hey, is this a account that's actually verified in this name? Somewhere down the line they'll find out that that's actually a cannabis applicant, let alone a licensed operator. So what we're seeing in the state of Michigan, it's consistent with other states, is that having those assets for the company, especially new companies when they're being created, just doesn't necessarily happen. So at least from my personal experiences in working with clients and my other colleagues here, they are usually being sourced from the supplemental applicants themselves, either through bank accounts or property interests, or just through investments, whether those are line of credits or promissory notes, for some investors trying to get some money into the company for a good return on their investment as far as interest rates and everything.
All right. Thank you very much. We do have other videos, I think, on that topic as well. Mm-hmm. Although, I want to talk about or answer a question from Will Ward, right? Because he's asking about micro business licenses. We definitely have a prior video on this particular question. In fact, or this particular issue, this license. In fact, I definitely welcome people to look at that video, because I think it's at least 30 or 40 minutes long, because it is a very interesting, fascinating question to the degree to which a lot of people are interested in, right? And the reason is clear. A micro business license is something that was a license that was authorized by our Michigan Regulation and Taxation of Marijuana Act, and the intention was to permit those that are operating small businesses to be included within our industry, so they're not pushed out of the industry. So a micro business would be given the opportunity to grow up to 150 plants, while also that same licensee would be given a license to process those plants into THC extracts or cannabinoid extracts, and then also have their own dispensary or retail establishment as well, all by one licensee. Other licensees cannot enter or cannot sell products within that licensee, that micro business, and that micro business cannot then also sell its product to others. So it's what we call a vertical integration, and I think it has been proven in other states to be a very effective manner to ensure the continued inclusion of small businesses. The question is then, how do you get one, right? And as we've said, it's something that was passed by our Regulation and Taxation of Marijuana Act. It's not the applications for these presumably would not be available until December of this year, 2019. But that doesn't mean that there's nothing that can be done until then. As many people have seen, a lot of these municipalities all over the state are contemplating what types of licenses they may permit within their municipalities, or whether they'll permit any licenses at all. Well, that includes micro businesses, and I think that a lot of these municipalities kind of forget about that as well, because everybody has been so focused on our medical marijuana program and making a determination as to whether they should allow or provisioning centers, processing, cultivation. Perhaps they're not thinking about micro businesses, and so it's a great opportunity for those that are interested in a micro business to put that out there to municipalities and help them understand why that may be a really great opportunity for them, where they don't necessarily have to allow big business, so to speak, in their cities. They can just allow some micro businesses, maybe one of them, maybe two of them, maybe a mix, right? But it's important for them to understand that this is something available to them, and it also gives them the opportunity to diversify or to specify what type of licenses that they want in their communities, because perhaps they only want licenses or licensees, individuals that are operating that perhaps do have a small operation, perhaps that are in only one facility as opposed to multiple large facilities. And so we believe, we don't know yet, but we believe the capitalization requirements are going to be smaller. Perhaps the license, the regulatory assessment is going to be less in order to allow for small businesses and those with lesser capital resources to be able to enter that market. So it's definitely a great thing to have in our industry, because as many can see, have seen already, and many probably can admit that our industry is already becoming, a lot of people are coming in from other states, people that are already successful. They're already coming in building huge cultivation facilities and having multiple dispensary locations. And that's fine, but we can't forget about those small businesses as well. And in addition to that, I think a micro business is a great opportunity to effectuate some of the other requirements of our regulation and taxation of marijuana act. And specifically what I'm talking about are the necessity to build the rules for our social equity program. And that social equity program is a program that would permit and allow for those that have been disproportionately disadvantaged because of our prior marijuana prohibition in this state, to give them the opportunity to participate in our program as well. And a micro business, and also I think delivery services, are great ways in order to promote participation from those that have been historically disadvantaged, of course, including African Americans, women, those that basically have been, and even caregivers that have been, that have criminal records, right? Because they were trying to satisfy the needs of their patients, yet early on in our medical marijuana program were prosecuted and now have felony convictions on their record. These are social equity issues, and these are issues that have to be addressed, not just when we begin our licensing, but I think right now, which is a whole other story, but I think our executive branch right now should be doing things in order to address those that have felony records for marijuana possession or marijuana convictions. But that micro-business license is something that people can begin to think about now. Look for property now. Try to lobby those municipalities now and help them understand how valuable they are to the industry, how valuable they can be to the community. And also they are one of only 2 licenses, I believe, that permit the municipality to share in the equity or share in the revenue. Right? I believe that the micro-business license and the retail licenses, they're the only ones that get to share in that revenue. Is that right?
Yep.
Yeah. So when that revenue I'm talking about is our excise tax, the 10% excise tax. That's going to be divided amongst a bunch of different parties. And part of that, like 15%, I think, is going to go to the municipalities. And so having a micro business is going to qualify a municipality for that. So they need to understand that, because I really don't hear any of them talking about it right now. That's something that they all should be considering.
I think that's a great point about caregivers. I mean, they have been disproportionately impacted by the criminal prohibition on cannabis. Certainly not as much as African Americans, minorities, a lot of other groups, but certainly they have been kind of vilified throughout this process. And I always say it's a little hypocritical potentially to be licensing people for the same conduct that you're denying them for doing. And so, with the potential ouster of the licensing board, with the marijuana regulatory agency, hopefully you see some fixes there. I know Laura's having their work groups coming up with licensees, attorneys, individuals interested in getting into the business, and other stakeholder groups. What I'd like to see happen next is to address that and start creating that program for those disproportionately affected groups, because that can be kind of another piece of the pie as far as having licensure for micro businesses, for those smaller licenses for small companies. And then I think just the last advice I'd have for somebody looking to start a micro business is that really start assembling your team and start learning all the aspects of it. Because if you're thinking grow, process, provisioning center, you need to be juggling several different things up in the air at once. You need to have a retail storefront and deal with all of the things that go along with that. You need to be dealing with the cultivation of 150 plants, which is no small order. And then you also need to be processing and potentially converting that into edible food. So your core competencies are not just yourself. You're going to have to surround yourself with a team. Founders, Bells, while they're small, considered microbreweries, although they're now owned by bigger companies, craft breweries, smaller breweries are still comprised of hundreds or so of employees. That's different compared to tens of thousands or hundreds of thousands, but it still can be a pretty big operation even though it's considered a micro business. So that's my 2 cents about that, but it's definitely a big jump forward with progress as far as.
And those micro, I don't want to dwell on this too much, but clearly it's an interesting thing. Those micro brews or the micro breweries, they are successful, right? I mean, they're all over the place, yet they're very successful. And it's kind of the same concept, right? I mean, they're all over. There's like multiple of them, like all around my house. It's crazy. All right, so let's move on. Let's look at a question regarding caregivers. Had a couple of them about caregivers. This one in particular is about medical grow licenses. What's the role of a caregiver in a medical, I guess a commercial medical grow license? What do you think?
I think it depends on where you're at. I mean, the law requires somebody who has 2 years of caregiver experience to be employed on staff. That doesn't mean a member, a manager. Somebody could be a master grower, not setting policy, but supervising because they have taken the stuff that they've learned throughout the past 10 or so years and are bringing it to the facility in order to get you compliant. Other than that, I mean, I think it's kind of a supplement to it. The patient caregiver system still isn't going away. Those patients are still going to be serviced by those caregivers if they so choose. The caregiver can go, especially somebody who's in a wheelchair, patient with, severe leg issues or just mobility issues, would have their caregiver go to the provisioning center, pick up product for them and come and return it. But now they also have the added benefit of delivery services in certain locations from licensed provisioning centers. So it's not really, the caregiver model isn't going away. There's just alternative options that are kind of there running in parallel with the MMFLA and then soon to be the MRTMA licensed adult use facilities.
So another question that we received about caregivers is their interaction and relationship with municipalities and whether a municipality has to permit a caregiver to be in operation and in what fashion are they able to permit it or regulate it. And as Nick said, caregivers aren't going anywhere. The Caregiver Law, our Medical Marijuana Act, created our caregivers and our patients, and that's not going anywhere. So our MMFLA licensees for growers, provisioning centers, and processors, that's going to operate in one in one lane parallel to our caregiver law under the Medical Marijuana Act. And so as far as the manner in which that they're able to operate, the fact of the matter is, and the law is that a caregiver can operate anywhere they like, right? Now, they don't have to get a permission, they don't have to get any municipal approval, right? A caregiver can operate, as long as they're operating within the provisions of the Act, strictly within the provisions of the Act, a caregiver can operate anywhere they like. Now, that means in their home or an industrial building, in somebody else's home that doesn't have to be in their own personal home, or on a farm, anywhere in Michigan, right? So you can't go outside of the state. You have to stay within the state because all of our laws are designed to be implemented within the state. Nothing obviously is going to be permitted outside of our state. But also, a caregiver has to still comply with other applicable laws. So a caregiver cannot and should not have a grow that is interfering with a neighbor's ability to quietly enjoy their property. That is a right that all people have, to quietly enjoy their property. And so what I see a lot are caregivers that are growing in their basement or growing wherever in their homes or in a barn or in the out in the backyard. But they're doing so in a fashion that it's completely obvious to the neighbors. The neighbors smell it. Some neighbors don't mind. Other neighbors obviously mind very much, have children and don't want their children knowing that there's a grow next door. A caregiver has a responsibility to mitigate that odor, because if it becomes an odor that is interfering with somebody's ability to enjoy their property, basically if a neighbor can smell it and they don't like it, that is a nuisance. It's a public nuisance. It's something that not only is actionable civilly, meaning that neighbor can sue. In fact, I just instructed and talked to a neighbor, somebody called recently, like not a grower, a marijuana grower, somebody called here and was like, I'm a neighbor and I have somebody that's growing marijuana next door. The police refused to do anything about it because of course the police are like thinking criminally and they're thinking, sorry lady, but there's nothing we can do. And she asked me, what can she do? And I told her, I said, you can sue. You have a civil action. You can file a lawsuit. And at first I explained, maybe you just ask them to try to do something about it. I didn't necessarily say go sue them. But I did suggest that is appropriate. That's an appropriate course of action or cause of action because a grower, a caregiver, anybody, whether regardless of what you cannot interfere with a neighbor or another individual's right to quietly enjoy their own property. So a caregiver has to obey all laws, of course, most importantly, the Medical Marijuana Act, and ensure that their grow is not larger than it's supposed to be based upon the number of patients that they have, and of course 12 plants per patient. It has to be in an enclosed, locked facility. Nobody else can have access to it. Nobody else that lives in the home, no other patients are allowed to have access to it. And of course you can't cultivate more than what's reasonably necessary to ensure the uninterrupted supply of marijuana or medicine to their patients. And so provided that's the case, the municipality does not have to regulate it, despite what many people, including the city of Troy, may think.
Mm-hmm. And that's the tricky part because the MMMA says you can engage in the medical use of marijuana on behalf of your patients, which includes cultivation, anywhere as long as you're following those rules in an enclosed lock facility, except for a school bus, or correctional facility. Anywhere else, you're under state law allowed to engage in that conduct. Similar to what Barton was saying, though, like with nuisance laws, there's also laws that are applicable to everyone when you're moving away from the residence. So if you're talking about commercial buildings, industrial buildings, there are certain building codes and a change of use and a certificate of occupancy and building permits if you're doing construction that you need to get. And certain municipalities can say, no, we're not going to allow you to do that, either for good reason or for bad reason, but there are ways that they can say no. This has been a series of legal battles and conversations that have been going on with all the municipalities in Michigan. 2014, Trebeek versus City of Wyoming established you can't outright ban it. Since then, there's been some Court of Appeals opinions, DeRuyter versus Byron Township more recently, which is now going to be addressed by our Supreme Court. And that will hopefully address some of that uncertainty between what caregivers can do, where municipal rights kind of intersect, and how that affects the MMMA. So they have agreed to take that up. They are going to be deciding that, our Supreme Court here in Michigan, within the next few months, I believe. And sooner than later, we will have a resolution, at least more than we had before, about this issue. So it's definitely confusing. A lot of different things intersect. And that's why it becomes hard and confusing to kind of give a good, clear answer that's everyone's following, I think.
All right. Let's move on to, I think, the most asked question that we get, that I get, and in my opinion anyway, and it's about firearms. Firearms and a patient or a caregiver or a medical marijuana licensee or facility licensee and their ability to possess and purchase a firearm, okay? Let me give you my expert opinion about this. Federal law prohibits and this is what generally we're talking about, is the interpretation of federal law, right? Because there is no Michigan law that says that you cannot be in possession of marijuana and also you cannot be in possession of a firearm. There is no Michigan law that says that. Michigan law does say that you cannot be in possession of a firearm and also be committing a felony. So a caregiver that is growing in their home, that is doing so in excess and outside of the rights that are permitted through the Medical Marijuana Act, is then potentially committing a felony. Now that is another question because the Michigan Regulation and Taxation of Marijuana Act now has changed the definitions of what's a felony. But I have heard some prosecutors they like to believe, and I believe they're going to start charging people with felonies. And so it remains to be seen exactly how that's going to work out. Of course, we have our opinions about that, but bottom line is this: you cannot be in possession of a firearm during the commission of a felony. So how is it with respect to federal law? Federal law says that a person that is addicted to a controlled substance cannot be in possession of a firearm. That's a felony, and that is a federal offense punishable by a mandatory minimum of 5 years in prison. So the question then becomes, what is addicted to a controlled substance? And that is where the law, the case law, of course the statutory law is ambiguous. We don't know exactly what that means, and so that's why we don't see it enforced that often. In fact, I do quite a bit of federal criminal defense, and I've never seen somebody, not that it's never happened, but I personally haven't seen anybody charged with being in possession of a firearm because they were in possession of marijuana and addicted to that controlled substance. It's subject to interpretation, and so what I say is that, and what I believe that there is a law that supports it, is addicted to a controlled substance means to the degree to that it is a detriment to themselves and a detriment to society. So I don't think that's happening a lot with those that are using marijuana. They're using it perhaps, and they by some definition are addicted to it, but not to the degree to which that they are a detriment to themselves or a detriment to society. And that is why it is, in my opinion, perfectly permissible for somebody to be in possession of a firearm and be in possession of a medical marijuana caregiving grow, or just medical marijuana or recreational marijuana themselves. You can't be under the influence of it. That's another law. You cannot. Michigan law precludes and ensures that you cannot be under the influence of a controlled substance, any controlled substance, including marijuana or alcohol, while in possession of a firearm. But I'm just talking about that simple possession of marijuana. I believe that it is a lawful endeavor as long as you're not demonstrating that you have an addiction to it to the degree to which that you are in danger of yourself or other people. That makes sense?
Yeah, and that's pretty concerning when you think about it. If you're talking about addicted to, that's subjective. If you're talking about under the influence, even for patients, if they're medicating, maybe it's in their system, so it would be a zero tolerance policy type of thing if that were the criteria. But for under the influence, how would they really come up with that?
So under the influence is defined, I believe, as somebody that's materially and substantially affected by the ingestion or consumption of that controlled substance. So simply just being, very similar to driving under the influence, right? So just having marijuana in your system doesn't mean you're under the influence. But if you are consuming it through inhalation, certainly the first 30 minutes in general, people are going to be under the influence, and under those circumstances should not be in possession of a firearm. Of course, I would suggest that somebody shouldn't be in possession of a firearm if they've used cannabis throughout that day. I think just to be safe. And I'm not the type of guy that is always trying to explain when people can and can't, be in possession of a firearm. But it's a question that we get a lot, and there's a lot of confusion about it. People are like, well, federal law prohibits possession of a firearm if you're in possession of marijuana. No, it doesn't. It prohibits being in possession of a firearm if you're addicted to that controlled substance, which is, that leads to really federal law and whether marijuana should be a controlled substance, which is what you talked about earlier, that bill that was introduced, which is something I think that's going to be acted upon, I think, this year. It would be very nice anyway.
And I think too the confusion over the gun possession thing came up when they issued that Code of Federal Regulations, and they were talking about that specific issue, and they changed the form that the gun suppliers are supposed to be, having people fill out, where it says, "Are you addicted to a controlled substance?" And what they interpreted was that any patients automatically have to check yes, regardless of if you actually are addicted. The way that they were interpreting it was that you have a card, you have to check yes. If you check no, you're committing fraud or misrepresenting that actual fact and lying on this gun application. And if you check yes, somebody is not supposed to sell you a gun. And so there's the answer to that. There's the answer to whether or not you having one previously could get you in trouble. There's just a lot of things, like all of cannabis law, where there's so many different parts that have intersected with it now as it continues to keep pushing towards legalization, and more of those laws intersect and actually kind of supplement and intertwine with it, there's going to be tons and hundreds of questions that still have to be answered just like that, and many, many more with CBD and food, with all these other things that still just haven't been able to be answered because the only answer before was it's federally illegal, that's a no-no. So.
There's many bodies of law. There's different courts that are interpreting these different bodies of law, and they seem to be contradictory sometimes. And then you add that to our ballot initiatives that we, get into making law, and it becomes a complicated manner of interpretation, and that's what courts are for, and that's what we'll see in the future. And so, as lawyers, it certainly is something that will keep us busy for a while.
Yep.
Any questions that you have?
And I think none really specifically pointed. People are just really trying to understand and appreciate the process for applying for a cannabis license. Where do I go? What do I do? How much does it cost? What's the municipality like? It's not cookie cutter. Just like with capitalization, I think every situation's different. Every municipality is different. When you should get started is different. How much money you need is different. So, with all these questions what's the role of the municipality? They can either be hands-on or hands-off. They can either make you jump through 80 hoops and set a bunch of booby traps around the way to get you to maybe not go through that process, or they can be very open and just have you fill out a simple form. Cost of obtaining a license, the reality is, as I mentioned with capitalization, it can get really, really high with how much you need to actually spend to be compliant and competitive and get up and running and establish a brand and deal with recalls and so on and so forth. So all of these questions are really general, and case by case they can be answered once we get to know you, or anybody else gets to know you and your specific company and your plan and your goals. But we're trying to answer these questions. You hear them the most often. It's just so difficult to, and some might get frustrated just not knowing, how the step one process goes. Why is mine taking several months? Why does Laura ask for this bank statement I gave you 3 times? I think it's just, knowing more about it, and people don't like uncertainty. So I understand that. And especially Laura changing the application process around and, tweaking things here and there, board review, marijuana regulatory agency. I think that just gives people more reason to be confused and not know what the process is. So I think generally knowing right now, as it's happened in Michigan, as it's happened in other states previously, it's evolving. There's not always answers. It's on everyone to work towards getting those answers and really knowing that we're all in this together. Even working with uncertainty and unanswered questions, I think, is the best. Being comfortable with being uncomfortable and not having all those answers there for you.
Okay, if you're still with us, thank you for watching. We're going to wrap it up there, and I can, of course, direct you to our previous videos that we've done, 86 of them evidently. They're all on YouTube. They're also on our Cannabis Legal Group Facebook page. You can get more information also at our website, cannabis-legalgroup.com. So for now, my name is Barton Morris. This is Nick Galendez. Thank you again for watching. We'll be here next week, next Friday at 2 o'clock. Please tune in then.
Have a good weekend.